Will you say it again, George, please?
The gentleman cites a famous instance in which Andrew Jackson refused to carry out the executive portion of a mandate that arose by implication from a decision of the Supreme Court. Was he guilty of a high crime?
Well, first of all, from my reading, historical reading, I've been led to believe that's apocryphal. It's a resounding remark, but Roger Taney, whom he appointed as Chief Justice and was in his cabinet, denied that Jackson had ever made such a remark. But in any event, sir, we've got enough current offenses without going out to hypotheticals in Jackson's time. Here's a gentleman.
Right here, sir. How were high crimes and misdemeanors presented? How and why were high crimes and misdemeanors defined as they were in the impeachment of Andrew Johnson?
We don't have transcripts of the deliberations of the Senate. In fact, one of the titillating things about these Senate judgments is that they're simply guilty or not guilty. And then all of the cardinals in the years later just try to fathom the mystery. What did the Delphic oracle really mean? So we don't know. We know that on the one hand, the counsel for the president insisted you required an indictable crime, and the counsel for the House insisted that it didn't. And so we're left there. We didn't have a clear delineation. But in any event, I ought to make plain to you what was at stake there. Perhaps you'll indulge me if I just speak for a moment about the Jackson impeachment, because it's the sole presidential impeachment that failed by one vote. To begin with, Jackson was involved in a struggle with the Congress which had the people behind it for a Reconstruction policy which Jackson severely disapproved. Now, whether or not Congress was right or wrong, or Johnson was right or wrong, needn't detain us. In order to carry out its policy, which revolved around occupation of the defeated Confederate states by the Army, the Reconstruction radicals needed control of the Secretary of War. And they had a man who had come through Lincoln's cabinet, remained in the Johnson cabinet, Edward Stanton, who was unfaithful to Johnson, was a tail carrier, and in fact drafted some of the anti-Johnson legislation. At length, a statute was passed which was designed to freeze him into office, allegedly designed. It is a very large question whether the statute in fact did cover him, but Johnson discharged him. And Johnson was then charged with violating the statute. And another major question you had, was the statute constitutional? Because as the Supreme Court held in 1926, and had been the fact from 1789 until the Johnson impeachment, it had been universally held that the president had a right to discharge his own cabinet officer. They were members of his official family. So this was a rather peculiar kind of a case. Number one, it involved a tremendous emotional issue. The North had won the war. They were exasperated by the black codes, by what seemed to them a move to defeat the Northern purpose in emancipating the slaves. And the people were united behind the Congress. So the nation was split, the North and South. We don't really have at this moment anything resembling it. As I read the polls, it seems that the people who are now ready for impeachment have come to outnumber those who oppose it. And I fancy that precious few would feel that as a matter of deep loyalty or emotional attachment to the president that he must stay at all costs. So we don't have a really divisive issue, I feel. I may be wrong about that. But in any event, you can get very little light on high crimes and misdemeanors from the Johnston impeachment. The one thing you can gather from it is that the Republicans broke ranks, that 7 Republicans defected, and thereby defeated impeachment by 1 vote, and wrote some very, very fine opinions on which they could solidly stand, that the impeachment would have been illegal.
Just to remind you, Professor Berger, that one of those Republicans was Senator Grimes of Iowa.
That's right. That's right.
Over here, about 5 rows back, sir. It has been suggested recently that the president may not be indicted for a crime while he is serving as president.
That is a suggestion that was first made in the last year or so. It has no precedent in history. And now, let me address myself to it. You know, lawyers go to very great lengths to get a client off the hook. They're not really the best authorities on matters of history because it's lawyer's history designed to acquit a client. But the phrase which is relevant is this: judgment on impeachment shall extend no further than removal and disqualification. Nevertheless, the party convicted may be indicted, tried, and so forth. Now, just to look at the dictionary, nevertheless means in spite of, notwithstanding. So the meaning of the words is, in spite of the fact that a man has been impeached, he may still be indicted. It doesn't mean he must first be impeached and then indicted. It says, if he has been impeached, notwithstanding, he may still be indicted. That's all it means. Moreover, the president would seek to get an immunity which was consciously withheld. Again, it's worthwhile to read the Constitution. I never look at it without learning something. An immunity from arrest, except in the cases of treason, breach of the peace, and felony, was expressly given to Congress. And it's a basic canon of construction, a rule of construction, that when the power is granted to one branch, it's withheld from the other. As the Supreme Court said in another case, it well knew how to grant it to the 2 branches, it only granted it to one. And I might say, by a miracle of prestidigitation, Solicitor General Bork, when Mr. Nixon had decided quietly to jettison Vice President Agnew, filed a brief in the district court in Maryland where the criminal prosecution of Agnew was under consideration, filed a brief gratuitously saying, on the same grounds I'm uttering to you, that the vice president can be indicted before he's impeached. And he proved all this with language that had been uttered solely with respect to the president, because all of the talk about impeachment revolved solely about the president. There wasn't a mention of the vice president till the very end of the convention, when he was just added without comment.
Down here.
Assuming there's a Senate trial and the president is convicted and appeals that conviction, who is president?
If the president should be convicted in a Senate trial of impeachment and under, I think we all understand, somewhat questionable circumstances at the moment, should appeal under judicial review, who is president during the appeal?
The president remains president, and the court would, of course, grant what we call a stay on the conviction. Now, mind you, I don't feel at all apologetic about my theory, and if I may mention to you, it's been taken up by nobody less than President himself and Mr. St. Clair, which doesn't make me think the less of my theory either.
Professor Berger, I know, is having a tough time in this large hall. His voice, I would like to ask one myself. Professor Berger, the president has said that there will be no more delivery of documentation from the White House to the House Judiciary Committee. What do you would recommend to Chairman Rodino or to the committee should refusal of a subpoena now ensue from the White House?
That presents a very grave question, and I'm glad to have an opportunity to comment on that. What we're witnessing, to strike a serious note, in my judgment, something which vastly transcends the revelations from the transcripts, is that the president is setting himself above the Constitution. He was not made a partner in the impeachment who could instruct the House how to conduct its inquiries. And nothing could be more fatal to the democratic process than to encourage a president to set himself above the Constitution with the acquiescence of the American people. Now let me read something to you here. In 1807, Aaron Burr, who had been vice president, was charged with treason, was being tried before Chief Justice Marshall, who was sitting on circuit. They used to travel around a circuit and sit in various places. He was then sitting in Richmond as a trial judge. Aaron Burr wanted to subpoena a certain letter from Jefferson, and if Jefferson wouldn't supply it, he took the precaution of subpoenaing Jefferson himself. Now hark to what Jefferson's lawyer, George Hay, who was the United States Attorney, said. I never had the idea of clothing the president with those attributes of divinity. That high officer is but a man. He is but a citizen. And if he knows anything in any case, civil or criminal, which might affect the life, liberty, or property of his fellow citizens, it is his duty to go before a court and declare what he knows. And what would be the process in case he failed to attend? Why, the common means would be for the court to issue an attachment to force him. Now, mind you, this is merely to be a witness in a case against a third person. Think how much more important it is when the president himself is being investigated. Now, what is the machinery? It's machinery from which the House Judiciary Committee shrinks because they don't want to get into the meat grinder of the courts. They don't want judicial review, and they have a right to feel independent. In England, if the highest minister refused to comply with a subpoena, he was just thrown into the tower, and that was the end of it. See, look at the gulf that has come to separate our notion of the president. He's but a man, said his own attorney, and an attachment would issue to force him. Now bear in mind what happens against the ordinary man who's in contempt of Congress. First of all, it's a crime by statute. he can be thrown in jail for criminal offense, as a criminal offense. But of course, we mustn't ask Mr. Saxby to prosecute the president. The second thing is that the House itself, what happens when a subpoena is ignored, the House is asked to summon the offender, hold him in contempt, and if he doesn't come, they instruct the sergeant at arms to arrest him. If he remains in contempt, he's thrown in jail. Now, doubtless Chairman Rodino would be aghast at the thought of sending the sergeant at arms to the White House to arrest the president. I can assure you the president wouldn't be aghast to send his sergeant at arms to arrest Rodino. So, I'm a man that's governed by logic. I see that the president's a man like every other man, that the separation of powers doesn't protect him, that contempt is enforceable by commitment, by arrest by the sergeant at arms, and I would, even from the standpoint of drama, let's not just talk about like old women wringing our hands about a confrontation, let's really have it. Let's go down to the White House with a warrant.
Professor Berger, we are so grateful to you, and we have had an evening of charm, great wit, and scholarship, and we thank you so much for coming here. Good night to you all. Professor Berger, I forgot something. Professor Berger will be in the Pioneer Room of the Union at 9 in the morning for about an hour or a little more to meet with students of all ages.